Hi, good afternoon, everyone. This is Rajiv Khanna from immigration.com, the losses of Rajiv Khanna PC. Today is July 23rd, 2015. This is our bi weekly conference call for the community held every other Thursday, where we answer the questions that you have posted and, if time permits, new questions. Uh, Let me get started right away. I have my Twitter notification running in the background. The Twitter account is immigration.com. You feel free to tweet as we are talking. I'll keep checking. That said, let's begin with the first question, which is Calgarian 74. Canadian citizen is here on a T1 TN visa. Can I work as an independent contractor? The answer is no. As far as I know, Canadians cannot work on a 1099. But we've done recently, a couple of weeks ago, a case, maybe a little bit more than that, 3, 4 weeks ago, a case where there's a Canadian company which is wholly owned by one person, and there's an American company that wishes to employ that Canadian as a consultant. So the Canadian company and the American company got into a contract. Pursuant to that contract, the Canadian company then sent the employee on a TN visa to the United States. The salary is being paid by the Canadian company, not by the US company. And the US company pays the Canadian company directly. This worked out quite well, no problems. We got our TN. Uh, the gentleman is working here. So that kind of a setup is possible. But to the best of my knowledge, you cannot be an independent contractor on TN. Next question from Bhuta Singh. Father entered legally in 89. He's a US citizen. Mr. Singh is a US citizen. His father entered in 89, lost his passport. No proof that he entered legally. So he left in 1998. My problem is, I think he's now subject to the 10-year bar. So, interestingly, if you are the parent of a US citizen and you have lived here unlawfully for even 50 years, as long as you have not traveled outside USA, you can actually get your green card adjustment of status within the United States as long as you entered legally. But in this case, I think you've got a problem that your father has become subject to 10-year bar. From what I can see of the facts here, it appears to me that there is no way around that. Okay. Next question is Pankaj Kulkarni. Indian citizen H-1B visa. He came to USA from Jan 2012 to June 2013. So the question is, can I use this prior approval of the H1? And the answer is yes, because you have received an H1 approval within the last 6 years. Actually, I'm sorry, guys. I forgot that I had changed the format of these calls. Let me go back and start with the first question I answered. Mr. Muhammad, if you are here or anybody has a question on the TN issue that I just discussed, press *5 on your phone. Only the TN issue. *5. Okay. Mr. Singh, Bhuta Singh, if you are here and you have a question or a follow-up question on entering USA and being subject to the 10-year bar, press *5 on your phone if you are here. *5. Okay. Not here. Let's go to the next one. I'm also watching our Twitter account, make sure that nobody's tweeting to us. Pankaj Kulkarni. So if you are here, press star 5. Because you've got your H1 approval in the last 6 years, you are cap exempt and you should be able to get approximately a little bit over 5 years. Uh, no, January 2012, a little bit over 4.5 years or somewhere there of H1 again without being subject to the quota. Press star 5 if you have a question on this. Okay. Mr. Singh had a follow-up question, Bhuta Singh. You have a Freedom of Information Act requested for the entry record of your father. See, my problem, Mr. Singh, is the way I see it, your father is subject to 10-year bar. Again, I don't know all the facts from what you have described to me. Assuming that after the expiration of his I-94, which was issued back in 1989, if he stayed here for 1 year unlawfully, he is subject to 10-year bar, and the bar attached to him when he left USA. Mr. Singh, if you're on the phone, press star 5. Star 5. If you have a follow-up question, press star 5. Let me double check if you guys can hear me okay. Give me 1 second.
The conference is now in conversation mode.
Can everyone hear me okay, folks? Just checking.
Yes, we can hear you.
Very good, sir. Thank you. Thank you, ma'am. Okay.
The conference is now in presentation mode.
Now, here is a frequently asked question from Lippy. Lippy says, I entered USA, and this is about telecommuting and working from home when you're on H-1B. I entered USA in Jan on F1, completed master's working for a reputed US organization on H-1B. I don't go to the office, I work from home. Can telecommuting job cause any issues during visa stamping? And the answer is it can. When you have a telecommuting job, in most cases, what we do is we actually get an LCA for that location. I think that is the proper method to do things. So make sure that you have an LCA for your home location. You can always come back on H4 Lippy if the H1 is denied, and your husband does not have to go with you. It is not necessary to go as a family, but the option of coming back on H4 is always there. Do I need any extra evidence to prove that I'm telecommuting? I would just look, the way I do these cases, we always get an LCA for the home location. So if your employers have not obtained an LCA for you, I think they might need to do an H-1B amendment depending upon the facts of your case. So before you go for visa stamping, it would be a good idea to discuss it with your lawyers. In my view, the safest thing is to have an LCA and that location specifically approved under the H1 process. Folks, anybody has a question on this, press star 5. A question on H1B telecommuting working from home, press star 5 on your phone. Okay, let's go on to the next question. Himadri Nath. In this case, what has happened is Dr. Nath is a physician. So he entered on H-1B for residency and never filed for a green card, and he entered in 2009, so he is running out of time on H1. He's going on to J1. So if I get a job on J1 waiver, do I still have to satisfy the 365 days of outside US rule? As far as I know, Dr. Nath, there is no exemption from that. There's an exemption if you are a Conrad 30 waiver case. By the way, Conrad 30 is also expiring in September, and the new bill that is pending for its reauthorization, I think, if I remember correctly, that bill might have something for somebody like you. I think that bill, I haven't read the bill, because unless the bill moves along a little bit, we don't even read it. I think that bill has something for physicians because many times by the time you finish your residency, sometimes like uh, we have neurosurgeon clients, their residencies can run many years, so you don't have enough time on H1. I think there might be something in there, but as of now, as of today, as the law stands, there is no exemption for somebody like you. You would have to be outside USA to regain the time on H1. The only exemption that exists under the H1 for physicians is if they are a Conrad 30, they are not subject to the quota. Okay, so if you're a Conrad 30 waiver, you're not subject to the quota. Dr. Nath, if you're on the phone or anybody has a question on what I just discussed, press star 5. Star 5. Okay. Let's go on to the next question, which is Sarita 24. 485 pending, priority date December 2006 in EB3. I have a BTech degree and 10 plus years of experience. Can I convert EB2 to EB2? This is a question that is asked quite frequently, and we've covered it many times. And the answer, Sarita, is yes, you can. Okay. It depends. Everything depends upon the facts of a particular case. But your employer or another employer can offer you a job that requires at least a bachelor's degree with 5+ years of progressive experience, and you can actually then get an EB2 based green card. Somebody just raised their hand. I'll get to it in a moment. By the way, once again, I remind you, immigration.com is my Twitter handle. Immigration.com. It's on our homepage, immigration.com, on the right hand side. Also on the forums on the right hand side, you can tweet from there while I'm still talking, so it's not a problem. I'm checking my tweets. So going back to Sarita, yes, you can do an EB2. That is certainly possible. Let me go to the raised hand and see what issue we are addressing. And Sarita, if you are here or anybody has a follow-up question, you can also press star 5. California, go ahead, please. California. California, go ahead. We can hear you. Area code 949, go ahead.
Oh yeah. So I had the question regarding the previous question that Kumadri asked. That's regarding that completing the H1B 6 years.
Yeah, I know, Dr. Nath. I see.
So
yeah, I see.
Hello?
I see your question, Dr. Nath. Go ahead.
Yeah. So there is no any way that person can stay unless he goes on dependent visa, right? After completing 6 years in USA.
H-4 EAD,
H1B.
that is correct. You cannot reset H1 unless you are outside USA for 1 year. That is correct.
Oh, okay. Okay.
All right.
Thank you.
You're welcome. Oh, Dr. Nath. Oh, I guess. All right. Let's go on to the next question. After Sarita, the next question is Gautam V. Indian citizen doing masters in Canada on student visa. Electrical engineer. First, he's got a very exciting job offer, and the employer thought they could do an H3. H3 is a very specific visa for very specific purposes, so obviously they decided they couldn't. So is there any other way, since we don't have H1B right now? Obviously, Gautam, the only other thing that I can think of is an L1, which works as follows. If this company, which is a big company, also has a branch in Canada or anywhere in the world where they can place you for 1 year, you can then come into the United States on L1 visa, which has no quota, and it's a very attractive visa for many reasons. So L1 is the only other option. Coming to USA to work, H1 is a very unique visa. It does not have too many replacements. Okay. If you are on the phone, feel free to press star 5. If you have a follow-up question, star 5. Okay. Here is a frequently asked question: applying for H-4 EAD while H-4 is pending. So Shivani wants to know, if I have an H-4 pending, it's not yet approved, can I apply an EAD? And the answer is you can, but USCIS has said they don't like the idea of separating the applications. It can cause delays. Personally, I think that's baloney. I would file it if I were you, because you have two options. You can premium the H1 and then H4 gets premiumed, kind of piggyback on it. And then once the H4 is approved, file EAD, or file EAD now. As long as you have a receipt number, I don't see why it should be a problem. So your choice, I would file it. Shivani, if you are on the phone, press *5. Anybody has a question on this particular aspect of H4 EAD, press *5. All right, let's go on to the next question. Mountain Hope says, this is Lokesh. He's working for company A, and his new labor has been approved, hasn't filed the I-140 under EB2 yet. But another company, company B, oh, I'm sorry, the other way around. He's working for company A who's got a new labor approved, yet to file I-140 under EB2, but he's got another EB3 I-140 approved through the same company. Future employer has an EB2 approved. So he's got one EB3 through this employer, employer A, one EB2 yet to be filed, labor is approved through the same employer, and a future employer has gotten his labor approved. I have a plan to visit India in September. By the time if I get advanced parole, can I use them to come back and still work for company A? Yes, you can. Is it safe to join company B once I get EAD, or should I wait till I receive my green card? That's up to you. I don't think you're losing any options by joining company B, because if company A holds the jobs open for you and something doesn't work out with company B, you could always go back to company A. In fact, I'm right now dealing with a case like that. There are some issues. Government can ask you, why did you leave company A and go to company B? Is the company really holding the job open for you? Who is doing the job while you are gone? Does the company still have the ability to pay wages? Those issues can crop up. They don't always do. But theoretically, all possibilities are open. Folks, *5, anybody has a follow-up on this issue? Once again, I remind you, Immigration Calm, our Twitter account, I'm holding that open as well. You can tweet Immigration Calm. Okay, one raised hand. Let's see what the question is. And this is from Missouri. Missouri, go ahead, please. Missouri.
Oh, yes. Hello, Rajiv.
Haji, hello, how are you?
Hi, this is Lokesh, and I got this question. Thanks for the answers, but I want to add one more question. Like, I work in a different place, like Oklahoma, but my family lives in Missouri. So I don't have a permanent residence there, but I file taxes in both the places. So I keep on shuttling from there every 2 weeks. I shuttle from there to here to visit my family and all. So while they're applying for 85 in 385 form, should I mention both addresses or only where I'm permanently staying?
I think you should mention where you are permanently staying. At the same time, you should attach a letter explaining your situation. Why take a chance with it?
Okay.
Okay, personally, I don't think it's a problem at all. It's a very small issue. Don't worry about it. All right? Good
Thank
luck.
you. Great. Thank you. I appreciate it.
You're welcome.
And also, once I get my EAD, once I get my TC, so is there any ideal time period I need to work for the employer B, or if everything good, so I can continue there, but if, things will come, different ways, always with the employer. So how many months is the actual time I need to work with them?
If you go to Google and do a search for the site immigration.com, right now we are implementing a new search, so our search is not working. So if you go to Google and say the phrase that you are looking for, how soon can I leave? Do a search on how soon can I leave, comma, uh, site colon immigration.com. If you do this in Google, you'll pull up the documents that explain to you how this works. I have many entries on this. Bottom line is,
Okay.
the day you get your green card approval, you should have the intent to stay there and not leave. But if 10 days later your intent changes, I think it's okay. So review those answers that I have given, and if you still have questions, we can talk again in 2 weeks. All right?
Okay. Thank you, Rajiv. I
You're welcome.
appreciate that. Thank you.
Take care. Bye bye. Yeah, once again, let me explain to you how the search works. I mean, most of you are IT people, probably know a lot better than I do. But if you wanted to search the site immigration.com using Google, you would type, for example, the phrase I just mentioned, how soon can I leave? And then you put site, space, site, SITE, colon, immigration.com. And then Google searches only immigration.com and pulls out those documents. We should have the new search implemented in a few months. It's going to take a while because we have a lot of documents. Our text-based database was several gigabytes. Several gigabytes of text is a lot of text. So they were telling me that they are still working on it. We'll see how soon that gets implemented. In the meantime, just use Google. Okay, let's go on to the next question. Lokesh, we just finished. Shalom 001. My problem is I don't know which country you were born in. Okay, because nanny visas, or what is H-2B visa, is not even available for Indian citizens. Okay, so I would actually, if you're on the phone, I would need to know the country you were born in and the country you are a citizen of. But if you are India born, you will not be able to take any advantage from quote unquote a nanny visa. And in any case, H-2Bs are not the best visas. They are problematic, they are temporary, they're difficult to extend. So normally I would not even advise it. I would want you to look at other options as a student, such as OPT, optional practical training, and H1. Okay. If you're on the phone, Shalom, press *5, or anybody has a follow-up question on a nanny visa, press *5. Okay. Let's go on to the next question. Oh, there's one raised hand, sorry. And this is again California. California, go ahead, please.
Yeah. So I have this is not Sanon, I'm a person, but I have a similar line of the question.
Sure.
So, like, if the same case, like, if person is not in technical or in like computer engineering field, still he can file the H1 and then work here.
Yes. Let me explain to you how H1s work. Actually, I'm sorry, this is completely off topic. Maybe very slightly on topic. All right, I'll address it. But H1 is available for any job that requires a degree in a specific discipline. So, for example, if there is a job of an economist job requires a bachelor's degree in economics at the very least. That's the job for which you can get an H1 if you have either a degree or a combination of degree and experience. Okay, so if you have a BA in arts, for example, in India, which is called a liberal arts degree, you won't qualify unless you also have experience on top of your education. But if you have a degree, let's say BA honors economics or BA economics, and it's a 4-year degree, or you have experience on top of the degree, you will qualify for the H1. Does that make sense?
Yeah. Thank you.
You're welcome. Okay, let's guys keep it on topic, please, so that we can then finish the questions that have been posted, then get to new questions. Okay, Suri 8873 says, regarding my brother, came to USA on L1B for about 1 year and 11 months, then came again on H1 for 4 months, then again on H1 for 6 months, 1 day. Total is 5 years and 9 months and 10 days between 2008 and 2014. So is he eligible now? He's been, so around October 2015, when he's been outside USA for 1 year, he wants to come back. You see, the problem with that 1 year clock reset is you can't get quota exemption. Okay, if you've been outside USA and you're resetting the quota, resetting the 6 year time, you cannot use the quota exemption. There is something called remainder option. So let's say I have used up 4 years of my H1, then I go outside USA for 1 year. I have two options. Either because I've been outside USA for 1 year, I can come back for full 6 years, 3 years, but I would be subject to the quota. Or I can come back for 2 years, which is remaining from my original 6 years of H1. 4 years I was here, 1 year I was outside. I can get 6 years back, but I'll be subject to the quota. I can be exempt from the quota if I decide to take only 2 years. That's called the remainder option. Okay. Anybody has a question on this issue, or if Suri is here, Mr. or Miss Suri, press *5 on your phone, *5. Okay. And this one comes to us from New York. New York, go ahead, we can hear you.
Yes, yeah. So he won't be eligible for quota. He should serve in the quota for 6 years.
Well, because see, he's been in USA roughly for 5 years and 9 months. So if he wanted to be quota exempt, he would get an H1 for approximately 3 months only. Okay. Now I want to actually I want to add something. When we do the H1 calculations, I haven't done the whole calculation. He may have a little bit more than that. If in any 12-month period you have been in USA less than 6 months, you can actually claim the whole year. So let's say I come to USA for 1 year and 3 months. Those 3 months will be ignored. I can get the whole year back for that 3 months. Understand?
Oh, okay. So within a year, if he stays less than 6 months, he can claim that whole year.
The whole year. Any 12-month period, if he's here, that way, if he can, he could actually be exempt from the quota and claim that time, and also start the green card right away, and that would then get him further H1 extensions. He's then exempt from the quota and getting H1 extensions. Okay?
Okay. Thank you.
You're welcome, sir. All right, there's one more raised hand. Let's go to that. And this is from the delightful, beautiful British Columbia, Canada. Go ahead, please, BC.
Yeah, Rajiv, I want to ask, I work on TN for last 7 years, and if I apply for H1, it would be exempted from quota or not?
TN, being on TN does not give you quota exemption, sir.
No, for H1. If I apply for H1 for green card, would it be exempted from quota, or it is same under the quota category? Because I'm living US for last years.
No. Look, have you ever had an H1 before?
No.
Yeah. Being on TN does not give you quota exemption. No. If you had H1 before, you could have gotten H1 quota exemption. But you have only had a TN.
Okay.
For example, if you had an L1, that does not make you quota exempt. If you have a TN, that does not make you quota exempt. Okay?
Okay, makes sense.
Good luck.
Yes. Thank you.
You're welcome, sir. We just finished Mr. Suri. Let's go to Max. 6 years got expired. They have not, employer has not applied for green card, and they did nothing. Currently on H-4 visa. Can I have a new employer file a green card for me? Yes, you can. Is there going to be an audit? Not necessarily. I don't see any impossible risk here. Once the new employer files green card, can they use my old H-1B number? Well, hang on. You don't need quote unquote an H-1B number. Let's look at your situation for a second. If you stay in the United States, Max, and because of a green card, you become eligible for an H-1 extension, you will get an extension and you will be quota exempt. Okay? So no problem there. Even if the old employer cancels the H-1B, you would still be quota exempt. Okay? If you are on the phone, Max, press *5. *5, Max, if you're here. Okay. Let's go on to the next issue. This is from Joe City. LCA amendment. One of the questions is, what the heck is an MSA? Well, MSA is Metropolitan Statistical Area. There's actually a lot of confusion in this. One good way to find out what the MSAs are, you can go to flcdatacenter.com. F as in foreign, L as in labor, C as in certification. FLC Data Center, center spelled the American way, not the European or the Indian way, CENTER, okay, not CENTRE, CENTER. So flcdatacenter.com, and then you enter the state and the county. It kind of gives you an idea of what the MSA is. But look, my concern is that going by the MSA, and actually I came close to filing a lawsuit against the government last year on this issue, and they backed off. I think they would have lost this case. The regulation does not require us to be in the same MSA. The regulation only says that an LCA is good for an area of normal commuting distance. So if the normal commuting distance falls outside the MSA, but it's still, let's say, and we had a case like this actually a few years ago, about 6 or 7 years ago, where in New Jersey area, somebody was traveling 75 miles. And the government came after us saying, well, 75 miles is not normal commuting distance, and it's a different MSA. On both these points, I won because we were able to show, number one, in New York, New Jersey area, 75 miles is normal commuting distance. Okay? And two, even if the MSA changes, the regulation only requires normal commuting distance as the criterion, not the MSA. So the government has created a lot of confusion with their own misunderstanding of their own laws. Please don't make these decisions yourself. Talk to a lawyer, preferably a good lawyer, because these are some minor issues. And while you can ask people and they might have insufficient experience or knowledge in this area, you must talk with somebody if you have a real issue, whether you should be doing an amendment, on H-1 amendment, etc., and so forth. So can you get this information online? Certainly. If you are within the same MSA, of course, you are very safe. But if you are outside the MSA and still within normal commuting distance, I would say you're still safe. Okay? So that is the bottom line. *5 if you're on the phone, Josui, *5. *5. Okay. Manish wants to know, he was in USA from 2007 to 2008 on H-1B. So within the last 6 years. Then he got another approval but never got it stamped. I think you are cap exempt because of the 2008 approval. Okay. So I think that would work, Manishji. If you're on the phone, press star 5. Okay, we have one raised hand already. This may be pertaining to the first question. Let's see. So this is a question from New York. Go ahead, please. New York, go ahead.
Yeah. This is regarding the previous question, Rajiv, regarding the amendment. Actually, I have a scenario like my current my current H1 is expiring next year, July 2016. But I'm with I have a plan to move to another state, but with the same client in November. So can I wait and file the extension amendment at the same time? Like because the current H1 will expire next year, July 2016, and I've been moving in November. So
Well, first of all, what you're saying is right now you are not moving. You are staying in the same place, right?
yeah, I'm staying in New Jersey. Yeah, the same place at the time.
Okay. In November, you plan to move to another location for the same client, same project, same terms, correct?
Yes.
So can you file an amendment and extension and start working at that location while the extension amendment is pending? So first of all, yes, you can combine extension and amendment. And two, USCIS applies the receipt rule to these cases of amendment as well. When the receipt comes, you can start working at the new location.
Oh.
Okay. Make sense?
So when you do such that we can't apply the extension, it's going to be like, because my extension is expiring in July. So can I apply like November at the same time? Will they agree? I mean, will they accept that application?
So what you're saying is from July to November, I want to work here. From November onwards, I want to work in the new location, right?
Yes.
Absolutely. That is perfectly legal. Your lawyer should be able to take care of that. No problem at all.
Okay.
All right?
Thank you.
You're welcome.
Yes.
Bye-bye. Okay. Let's go on to back to Manish's question. I already answered. Manish is not here, so we'll go to Samir's question. CR1 visa interview at Mumbai. Can NVC change the interview location from Mumbai to New Delhi at this point of time? I think they can. Not only that, I think you can actually request consulates locally to transfer files if the files have already come there. So Samir, the answer is yes. NVC can change the location from Mumbai to New Delhi. As far as I know, it should not be a problem. 14th of August. I think you might want to contact the consulate where the interview is supposed to happen, which is Mumbai, and ask them, and you can email them, also contact NVC at the same time. Doesn't hurt. Okay. I don't think it should be a problem. I've never done it, but I don't think it should be a problem. Arvind Apte says, I'm a green card holder for the last 4 years and 9 months, staying with my son, want to apply for citizenship in mid-August 2015, which is next month. Physical presence will be completed. I was out of the US every year from 4 to 8 months, twice. See, when you are outside USA for more than 6 months, government can ask you for an explanation. But it does not affect your eligibility. As long as your intention was not to get rid of your green card or abandon your green card, you should be okay with a more than 6 month explanation, with a more than 6 month absence. But I would not want you to take my word for it. I would strongly advise that you consult with a lawyer, go over the details of your specific case, spend some time on it. Generally speaking, cases like these, when there's a good explanation, we've never had a problem. Okay. So yeah, they can ask you for additional documentation, even if you had no residence or source of income. Okay. Arvindji, if you're on the phone, press star 5. Arvind Apte. Okay. Oh, there you are. All right. Let's go ahead. Illinois, go ahead, please.
Hello.
Yes, we can hear you.
Yes. Rajiv, this is summary with regards to question number 17,
17.
the above question.
Okay. Yeah, the transfer of the
Rajiv, actually,
interview.
I forgot to mention that as the reason in 2013 my admission was withdrawn at H-4, and the reason for withdrawal was that I was entering on a non-immigrant visa H-1B, and I had intention to marry my fiancée who was LPR then, green card holder. The CBP officer came to me that I had intentions to marry my fiancée, and hence I was denied entry in 2013.
You were on
So,
Arvindji. Hang on, hang on, Samirji. You were on H-1B visa. Is that what happened?
yeah. In 2013, I was entering again on H1B.
Okay, but that's not a reason to deny you entry, frankly, or to ask you to withdraw your request for admission, because
Yeah, that was true. But the CPP officer was under the assumption that I don't have any valid position with my employer.
okay, that's understandable then. All right. So I don't think that's a problem. I did look at it. When I read your facts, I did see that your admission was withdrawn. See, when your admission is allowed to be withdrawn, it creates no permanent bar of any kind for a green card. So we are okay.
Mm-hmm. Can I accompany my wife to this visa interview so that she could convince the visa officer that she's facing mental, psychological, and emotional stress in the past 1 year? She was there in US and I was here in India.
Samirji, you are only trying to reschedule or change the location of the interview from um, uh, from Mumbai to
Yeah, the reason
to
I
New
was trying to
Delhi.
change was because of this thing.
I think you should communicate with them by email first. You want some written record of
Mhm. So do
you.
you advise me to change the location or is it fine with Mumbai if they allow the US citizen right to enter the consulate?
I think it's so much easier just to go through with it, because when you try to move things around, moving parts are never good with the government. The less movement there is, the better off you are. That's what I think. Okay? Hello? Oh, I think you got disconnected. All right. Going back to the list of the questions, after Arvind Apte, we've got Shashank. TPS. I'm sorry, Shashank. I have very little knowledge of TPS. We do not deal with temporary protected status. So our work is focused very sharply in legal immigration. And TPS comes up more often as a benefit given to people who would otherwise become unprotected. I would suggest you speak with somebody else. I have no idea how TPS interacts with your F1 and F2. Okay, then we come to Malana. Completed 6 years of H1B in August 2014. Before that, PERM was applied under EB2. Got a random query, not eligible for H1B extension, so changed to dependent. PERM is approved, but the employer doesn't have the ability to pay. They don't want to do I-140. Remember, there's a 180-day deadline. If you don't file I-140, the PERM is gone. You have to start all over again. Is there any way that my employer can funding issue? I guess can counter the funding issue. I do not know. That depends upon the particular case, but it certainly should be tried. No question in my mind about that. See, if you lose, first of all, it's going to be pending for about 6 months or so, the I-140. That gives you one H1 extension. If you lose, you file for an appeal, that gives you another H1 extension. So you'll get a couple of years work out of this, and you can even start a new green card in the meantime. Can I opt for further study? You can certainly try. You can go for MS, but if you apply I-140, that could be a little problematic. And if you want to reset the H1 quota, you have to be outside USA for 1 year. No question about that. So Malana, if you're on the phone, I would be happy to answer follow-ups. *5, Malana, *5. Okay. Go ahead, please. We can hear you.
Yeah, so this one banana, but this, I have a similar question actually. So you mentioned that if my form is approved, I can file for the H-1B extension. So and then I can get.
How is this
So
question?
how is going to
Hang
work
on,
with
hang
that?
on. How is this question related to what I just discussed? Don't do that, please. Okay. Don't do that. I answered it the last time around. There was no connection between what I discussed and the question. Don't do that. All right. Next question from Dipali. It says, I have a PhD in bio. She says, I am a PhD in biology. CAP exempt H-1B for the last 5 years. About to expire September 2016. I-140 has been applied on the basis of expertise in biology, NIW category. So, do I need to apply for a capped H1 if I apply for industrial position? Yes, of course. Can the approved I-140 help extend my H1? It can, even though you are changing your industries. Okay. But the problem is, if you are switching from biological sciences to information technology, unless it was some kind of bioinformatics, I think you could have a problem with your NIW, because NIW is given based upon an assumption that you will work in your own field. Okay, so that is where you're going to have a problem. I'm planning to apply for my capped H1 next year with respect to the IT job. So I think you will get your H1, but it can create a problem for your NIW. Okay, and I'm hoping you're on the phone, Dipali. Press *5, please. *5, Dipali, if you're on the phone. Dipali ji, press *5 if you're on the phone. Okay. Oh yeah, here we go. Go ahead, please, Dipali ji. We can hear you, Dipali ji. Go ahead, please.
Hello.
Yes, ma'am.
Can you hear me?
I can hear you fine. Thank you. Go ahead.
I have a few follow-up questions, sir. I understand that because I'm from biological field, it would be difficult for me to stay with my NIW if I move to IT, right?
I think it becomes questionable unless you can convince the government that this is still your field, like bioinformatics or biotechnology,
Mm-hmm.
or you can
Okay.
convince the government if you are asked to. They may not ask you to prove that, but if they ask you to prove that, you could also convince them by saying, if you can, in good faith, that you intend to go back to the field for which you were approved.
Okay.
Okay.
Another question I do have, that how we justify similar kind of jobs. I mean, if I can go to bioinformatics, so it would be easy for me because I have an academics in biology, right?
I do not know. Whatever the truth is, ma'am, I can't make up a story for you, right? Whatever the truth is.
Okay.
Yeah.
Okay. The second question I have is, my spouse is presently on H-4 visa, and because I have applied for my GC, can he move on to F-1 visa?
He can. We actually come into the, yeah, we run to the situation very often. Children age out, and even though they have been named in the I-140, technically government can raise an objection saying that how do we give these folks a student visa when they have exhibited immigrant intent. But as a practical matter, Dipaliji, I think we must have done 4 or 5 of these cases last year. I mean, in this 7-month period, I think we've got approvals on all of them. So even government understands that these kids who age out have to get some kind of status in the United States, and they are studying, their students. So student visa is appropriate. I think you'll get it.
Okay. Another question I do have, sir, that if I intend to move out of United States this year after I get my NIW approved, and I intend to re-enter on 2016 or 17, does it affect my NIW in any way? Because I'm from India and I'm hoping that I have a 6 year wait before I can apply for my 485.
Dipaliji, the most important point in NIW is always, hang on one second. I have a Twitter. Sachin, I'll come to your question at the end of the calls. Okay, stand by. Sachin has just tweeted to me. Okay, so the most important thing about NIWs is government wants to see an intention for you to work in your own area of expertise. So I think even if you left USA and you came back after a couple of years, as long as you could establish that you are going to work in your own area of expertise, I think you should be okay.
Okay.
All right.
Okay.
Dipaliji,
Question,
yeah, hang on, make it the last question
Hello.
because I gotta go on to other people also. So make it the last question, please.
Okay, sir. Thank you.
Okay. I was actually going to answer one more question, Dipaliji, but I guess. All right. Let's go on to Banyan Tree. H-1B petition was filed in October 2014, denied. Then you got an approval, but there's a gap in the I-94s. It's not a big problem. I've never had an issue with that. That's more of a technical and logistical issue. So I don't think you're going to have any problem with visa stamping. You can go to Canada, Mexico instead of India. I don't see any problem with the I-485. So I'm not worried about it. I think you'll be okay. It's, to me, it's not a big problem. They gave you an I-94, you're all set. Any questions? Banyan Tree, *5. Banyan Tree, *5. Press *5. Okay. So there's a couple of questions about if I've got a green card pending, can I get a tourist visa, for example, to come visit on Diwali? And the answer is you can try. There is absolutely no harm in trying as long as you are truthful. When you file the form DS-260, I'll get to the raised hand in 1 minute. I just saw a raised hand. So if you are honest about your husband living in the US and a green card pending, government can still give you a tourist visa. So try, but be forthright, be absolutely truthful. Okay, let's go to the raised hand. This is from Pennsylvania. Pennsylvania, go ahead, please. Pennsylvania, go ahead, please.
Hi, can you hear me, sir?
I can, sir. Yes, go ahead, please.
Okay. So I am Ritu's husband. I'm actually the petitioner for her. So her I-130 is pending, and thank you for your response. But my question is really around: can she apply for a tourist visa now? Since her I-130 is pending, and
Yeah.
understanding that
I just
I-130 is a
sure.
immigrant in sense versus tourist visa is a non-immigrant.
That's what I just answered. I said government may not want to give it to you, but there is no harm in trying.
Okay.
I do know people who were given a tourist visa, even though their green card was pending, especially those people who have either come and gone a bunch of times or have lived in USA and gone back. So I think it's worth trying as long as
Okay.
you are completely honest about it. I hope that you'll be able to spend Diwali together.
Okay, great. Just one last piece of that question. That if in case she does get denied for whatever reason, it won't hurt her green card application, correct?
It will hurt her green card application only if she gets denied for fraud or misrepresentation. Any other reason, no problem.
All right.
Okay?
Thank you, sir.
You're welcome. Good luck, sir. Okay, let's go on to today we had a little bit more questions than we normally do. So bear with me. finishing them up, and I will answer new questions once we are done with these. Um, See, Bob 87, here's my problem. If your H1 gets rejected and then you say, okay, I'm the employer, I have an in house job for the employee, it's a very difficult case to make because it often looks like you're just making things up. But if indeed there is a project in house for you and the employer files for it, I think that's okay. But you need to keep an eye out on the 180-day problem, because if you are unlawfully present in USA for 180 days, you would be barred from entering USA for 3 years. So you wanted to know how good is it to apply with the same employer for internal project. It's a difficult case usually, unless there's a genuine project. Will I get an I-94? Doubtful, because you have a gap in status, but you never know. Um, Visa is not an issue for these cases as long as there's no fraud or misrepresentation. The fact you were out of status is usually no problem, but not unlawfully present. If you're unlawfully present for 180 days, you have a big problem. And don't ask lawyers how to justify any situation, because no lawyer should be telling you how to make up a story. You can certainly say, this is my reason. Do you think this would be acceptable? That's okay. But nobody should tell you what to say to the consulate. You should tell the truth. I personally, in your situation, I would be very doubtful about this internal project deal unless they really have a solid case. This is something your lawyers can address best because it depends upon the specific facts of your case. If you're on the phone, Bob, press star 5. Star 5. Bob, star 5. Okay. Vittorio, wife got an H1B. I have an H4. She's getting terminated from the job July 27th. She's requesting change of employers, I believe is what COE means, with company B this week. So you're waiting for the LCA to be approved. Must company A pay her transportation cost even though company B is filing a new H1B? Yes, absolutely. If company A is terminating her position before the time contemplated under the H1, they have to offer to pay her a one-way ticket back to her home country. On the other hand, if the H1B, let's say for the company B, is not approved, only the LCA is approved, there is no such requirement on company B. They don't have to pay. Okay? Vittorio, if you're on the phone, press star 5. Star 5. All right. And this is California. Go ahead, please. California, go ahead. Go ahead.
Yes, yeah. So yeah, it was my question was if the company B should have paid for the way back at least in case it's going to be denied. That's it.
No, no, they don't have to pay. If the H1 is not approved, they don't have to pay.
Okay. So yeah, I think that was basically.
Yeah, but let me add another thing to it, that they are terminating, employer A is terminating my services. The fact that employer B is filing for my H1B does not change the duty employer A has of paying my ticket. Okay?
Right.
So
yeah.
employer A still has to pay.
Yeah.
All right. Good luck.
Yeah, the duty you mean? Yeah. Okay. That sounds good.
Good luck, sir. Bye bye.
Thank you so much, sir. Thank you for
You're welcome. You're welcome. All right. Let's go on to the next one. Durgesh talked with me and says, how do I say for my wife's visa status? And I told you it's very difficult to get this visa. Should I say illegal work? You can say work without authorization. Nobody uses the term illegal work. We use terms like work without authorization. And mention only if the DS-160 asks for it. For instance, if the DS-160 says, have you worked without authorization? The answer is yes. If it says, have you been out of status? The answer is yes. Because by working without authorization, you become out of status. You can certainly explain to the government that we never took any money. But that's how you would present it. If you're on the phone, press *5. Durgesh, *5 if you're on the phone. All right. Let me get to you first. Ji, Durgesh ji, go ahead, please.
So actually, I have one more question. Like, she was not paid in cash. So do I need to mention that also in the DS-116 because she barely worked for like over the period of 2 weeks, 3 weeks, and she was working only like 2 days, and it happened in a very early stage. So we didn't take any money
Yeah,
from the
I
owner.
I would only mention what the government asks me to mention. Okay, if there is a particular question in the DS, what is it, 160, 260, I can never keep it straight. In the DS form, if there is a question that asks you, have you been out of status? I think you'll have to say yes. And if there's a place to explain, you would explain saying that I worked without authorization only for 2 days, but I never took any money for it. I think it's okay to point that out.
Okay.
All right.
Okay. Yeah.
Anything else?
Thank you very much.
You're welcome. Good luck.
Thank you.
Then we come to Rajan. He has a question about EB2 perm process time. H1B is maxing out in November 2016. So the question is, can our firm get your case filed before November 2015? See, first of all, maybe you have some recapture time also from the last many years. If you have been outside USA, you can recapture that time. Can we do it in 3-4 months? Yes, if number one, the paperwork is complete, your experience letters are there, the job description is almost finalized, we can finalize the rest. Um, Another very important point is if the company is okay with level 4 wage, we can save some time there. But it is certainly something we can try. But remember, it takes 2 months just to get the prevailing wage. And then it takes 2 months just to get the case out of the um, job order process. We can run these things concurrently sometimes, but again, it is possible, but I would not be able to guarantee it. No lawyer should guarantee it. Okay. Um, Remember, you have recapture. Don't forget that. And also remember, if there is a gap, it just means that you'll have to spend a few days either outside the country or out of work. Um, it doesn't mean that you can't get an H1 extension. Um, if you're on the phone, Rajan, press *5. Press *5 if you're on the phone. Okay. Let's go to the next question. I'll come to the tweets that you have sent me. After I finish this, I'll come to the tweets, and then we'll do new questions. Indian citizen came to USA in 2007 for masters. OPT, then H1. In July 2014, employer said he might revoke my H1. See, my problem is, from your facts, Kiran, it looks like you might have stayed in USA unlawfully because your H1 was revoked in July 2014 and you left USA sometime after, let's see, when did you leave USA? Came to India in April 2015. So you were unlawfully present probably less than 1 year. That means you could have 3-year bar. 3-year bar. Okay. It looks to me like you have a 3-year bar from re-entry. You can try working around it. I would certainly advise consulting with a lawyer, go over the whole case. But it looks to me that you have been unlawfully present in the United States. If you're on the phone, press *5. *5. Kiran 16. Okay. Jai Ho, Is it fine to travel to Canada or Mexico after getting green card? Yes, if your job involves frequent travel, um, and it's just 2 weeks every month and then come back to base location for next 6 to 8 months, I don't think this is a problem. If they ask you questions, if your home address is here, your family is here, salary is being paid in the US, I don't see any problem. Okay. I think you have another question further down, or maybe not. If you're on the phone, press star five. Star five. Okay. I think this is the last question of the day, and then I'll start on the tweets and then the new questions. Um, can my spouse on H4 enter from a different port entry than my company location? Definitely, no problem. Can she land at any port of entry? Why not? If my work location is different from that mentioned in LCA, do I need an H1B amendment? Probably. Um, somebody has raised their hand. I'll get to it in a minute. Do I need to have a new LCA of my work location? See, there is a whole debate going on when should you get an H1B amendment. My rule is, if you are moving out of normal commuting distance, you've got to get an H1B amendment. If you're working for a new client in the same building, you probably have to get a new H1B amendment. So any major change requires an assessment by a lawyer, a good lawyer, uh, because I see a lot of strange advice floating through also. Somebody who's studied the issue, who's spent some time with the issue, they should advise you and make sure that you are protected. Okay. Um, but it's not something I can answer in the abstract. Any substantial change or move out of normal commuting distance would require an H1B amendment. All right, let me get to the raised hand. Florida, go ahead, please. Florida. Florida. Area code 813.
Hello.
Yeah, go ahead.
Hello, sir. How are you?
Good, sir. How are you?
I think I'm good, sir. Thank you so much. I think I can ask you a general question now.
No, not yet. I'll get to it. Give me a second. All right. So SPSN, do you have if you're on the phone, press star 5. JHO or SBSN, star 5. All right, let me go to the tweets first. Sachin says, got maxed out of H1B in June 2014, working from Canada with the same company, got I-140 approved and L1A. If I choose L1A and go, can I change employer? Sachinji, that's a difficult question to answer. L1A is very company specific. You can, if you have time remaining on H1, you can try to do an H1B transfer. But L1As cannot be transferred outside the related group of companies. If you're on the phone, press star 5, Sachin. Star 5. Okay. There are two people who raised their hands. Looks like one from Canada, one from California. All right, Canada, go ahead, please. Canada.
Hello.
Yes, sir.
Hello, Rajiv. Can you hear me?
I can hear you fine. Yes, sir.
Okay. Yeah. See, I have my 140 approved, and I also have L1A stamping in next 2 days. Now, if I go on L1A and later I want to change the employer based on the approved I-140 which I have, I mean, would I be able to do that?
You mean you want to change to an H1B again? Is that what you're saying?
No, I will go to US on L1A with the same company. But if they don't process my green card in EB1, then I would like to switch to another employer using the approved I-140 which I have currently while I'm in Canada right now. Right?
Who got your I-140 approved? Same employer, the L1 employer?
Yes, same employer got the I-140 approved. Yes.
Sachinji, you need to be aware of something. USCIS's thinking is, if the employer revokes the I-140, you will lose two things: right to further H1 extensions and your priority date both. Be careful.
Oh, okay.
If they are not going to revoke your I-140, You can certainly get an H1. It'll be good for 3 years, but you'll have to start another green card if they revoke the I-140, and you will not be able to get any more extensions except through the new green card process.
I see what you're saying. Okay, so the best option would be to, I mean, in case if I want to switch employer, I should just use my I-140, get H1 extension, and then do consular processing, go there instead of going on L1, right?
No, I don't know how you came to that conclusion. If you wanted to change employers, you would have to be prepared not to get any more extensions on that I-140. You'll get one if it's not revoked by the time the H1 is decided. You'll get one. After that, you'll have to start a new green card. If the old employer revokes the I-140, you won't get the priority date.
Okay.
Okay. So consular processing doesn't help you.
Okay.
All right.
I see that. Okay. I get it. Yes. Thank you, Rajiv.
You're welcome. Good luck, Satinji. Bye-bye.
Thank you.
All right. After this last raised hand, we'll start the new questions. California, go ahead, please. California.
Yeah. Can you hear me?
I can hear you. Yes, sir.
And it was regarding my question before, and I was wondering, what is considered the reasonable cost that the company A should pay for travel arrangement for my wife?
Okay, so this is Vitalio, right? I remember your name, right? Vitalio? Vittorio.
Yes.
Okay,
Yes.
so the question is,
Correct.
when an employer lets me go on an H1, what is the reasonable cost of the ticket, airline ticket? The answer is, they are actually required to offer you only an economy ticket, one-way ticket, not for your luggage, not for your family, just for you, the individual who was on H1. Whatever it costs, the law doesn't set an amount on it. Whatever it costs, I would say commercially reasonable. Whatever it costs, that's what they've got to pay. Okay?
Okay, perfect. Thank you. Thank you very much.
You're welcome. Guys, anyone has any question, press *5. Anyone has any question, press *5. 1, 2, all right, 3. Make sure you've raised your hand, please, because these are the last 3 questions and I won't go to any more questions. Very good. Let's start in the order that you called in. Back to beautiful British Columbia. Go ahead, please.
Sir, is this open for general question or not?
Any question, please go ahead.
Okay. If somebody is working on TN, can he apply for green card?
I actually covered this issue very extensively in the last couple of conference calls. It should also be in our frequently asked questions. And the answer is not a good idea, because TN is not a dual intent visa. If you are at the I-140 stage, your TN extension or TN entry can be denied. So normally, I either prepare people not to travel or extend. So start the green card in an early stage of their TN 3 years, or I convert them to H1 somewhere along the process.
Okay, thank you.
You're welcome,
Thank you,
sir. You're welcome. Bye-bye. All right, let's go to the next question. And this is Florida. Florida, go ahead, please.
Yes, sir. My question is, if someone has got his H-1B stamp in India, but never traveled on that H-1, and it has been done like 7 years ago, is he still exempted from the quota?
I think there are 2 issues here. Let me cover them both. And I think they would probably be exempt. Let me explain how. So the current thinking of the government is, once you get the H-1B visa stamped, you become quota exempt. The second issue is, your H-1 must have been approved in the last 6 years. But your example is, let's take back 7 years. That brings us to 2008. Okay. My H1 was approved in 2008, but it was probably good till 2011. 2008 to 2011. 2008 doesn't fall in the last 6 years from today, but 2011 does. And I think that's the number that counts.
Okay, so that means it is exempted from the quota.
I think so. It's always best to check with the government between the time they've talked to me and now if they've changed their mind about the counting of the last 6 years. But the last time I spoke with them or our office spoke with them, that's what they told us.
Okay.
All right.
Right.
Good luck, sir.
Thank you so much.
Oh, you're welcome.
Yeah.
Guys, I just also want to let you know that I always enjoy talking with all of you, and I appreciate the opportunity to hang out with you and whatever I can answer to the best of my ability and the time permitting. Okay, let's go to New Jersey. New Jersey, go ahead, please.
Rajiv, this is Isha.
Yes, ma'am.
I have a general question about my petition and filing amendment.
Yes, ma'am.
Right now, my current petition was filed like 2 years ago with client A through vendor B.
One second, one second,
Right now,
one second,
I,
one second.
I was
Hang on,
like,
hang on.
hello?
We are talking about H1B, right?
Yeah, H1B.
Okay, so you had a vendor and a client. Okay, then
Yeah, while I was filing my petition, I have client A through vendor B. And I took a break of 9 months for that client and I rejoined to the same client like 6 months ago. But this time I'm working for the same client and in same location, but the project was outsourced to some other vendor C and I'm working for vendor C through vendor D. So vendor C is considered as my client as of now because I'm on service agreement. So my question is, do I have to file an amendment or is it okay because I'm working on the same client location?
can I ask you why you were out of work for 9 months?
It's not like out of work. I was working remotely for some other client, work from home opportunity. So I took a break from this client, and once that project is completed, I rejoined this client with a new opportunity through another vendor who is like an outsourcing partner for this client.
While you were working for that other client, was there an H1B amendment done for you or no?
For the work from home opportunity, no.
Okay. I think you have a couple of issues here. One, in my opinion, when there is a change in vendor or change in client or change in project, I think an amendment should be done. Okay. In my view, an amendment should be done. Number two, I feel that there is a question about there being some shade on your status also, because you might have worked without a proper amendment for a job that you did from home. So, in my view, that fact should also be pointed out to the government so that you are covered from every possible angle. The petition should inform the government that for 9 months you worked from home and no amendment was done, but now you are going back to work for the same client, but by way of caution, they are filing an amendment. And I think that's the best way to approach this.
Okay, because I have my current H1 petition until next year. So, anyways, like after 6 months, I have to file for extension. So, my question is like, do I have to wait for 6 months and apply extension, or should I apply amendment right away?
I think you should do an amendment and ask for extension at the same time. I believe you should be able to get an extension even though it's more than 6 months. Um, I certainly think it's worth it. Okay.
Okay, so sorry, your voice got break up, Rajiv.
I would say that,
Can you repeat again?
in my opinion, both amendment and extension should be applied. Yes, ma'am. Right now. Don't wait 6 months. Right.
Okay. And with this amendment, we can request like for another 3 years or like how much ever period client gives the project, right?
I don't know how much they are going to give you, but it's certainly worth trying for 3 years from the date of the petition. they're not going to approve it for
Okay.
1 year plus 3, but I think it is reasonable to ask for 3 years from the date of the case. So 1 year plus 2.
Okay. Okay. Yeah, I have my I-140 also approved.
Yeah. So I would ask for 3 years.
Okay. Another quick question, Rajiv. Um, since we have this H-4 EAD, like say for example, if I move to H-4 EAD from H-1, then will my priority date and my I-140 everything would still be valid?
Of course. Whether you are working on H1 or H4, your I-140 that is approved for you specifically does not get disturbed in any manner.
Okay.
All
Okay.
right.
But I mean, since this I-140 is applied through my current employer since I'm on H-1B, so when I move to H-4 EAD, I mean, how does it work? Like,
That's a very
it
long.
all depends on.
That's a very long discussion. I can only answer in the hypothetical. Can
Okay.
having
Okay.
an H4 EAD interrupt an I-140? The answer is no. Now, how do I work? Whom do I work for? That's a totally different set of questions. Let's talk about it in a couple of weeks. I'm running out of time today.
Okay.
So
Okay.
we can talk again. Just post your questions. I'll be happy to answer them for you. Okay?
Okay. Okay. Thanks, Rajiv.
You're welcome. Guys, thank you everyone for being here. I will see you again 12:30 p.m. every other Thursday. And remember the phone number 202-800-8394, 12:30 p.m. Eastern Standard Time. Thank you and bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.